Yes, counsel. Good morning.
Good morning, Honorable Justices. For the record, Jeremiah Pollard representing the appellant, Robert O'Brien, here to address the recently enacted legislation creating the Harassment Prevention Order Schemes, General Laws, Chapter 258E. And with respect to the harassment prevention orders, although the statute sets out to eliminate certain types of conduct and speech, namely those motivated by cruelty, hostility, and revenge, the statute, upon careful examination, covers a wide range of protected speech, and as such constitutes a prior restraint on protected speech under the First Amendment as it's applied to the states through the 14th Amendment, the Declaration of Rights, and our Massachusetts Constitution as well. And
prior restraint in what sense?
in the sense that the statute itself covers, when looking at harassment as it's defined in subsection 1 in the definition of harassment, it defines any three acts that are willful and malicious. And taking the definition of malice, you have a further definition of anything that's characterized by cruelty, hostility, or revenge. So literally everything that the statute defines in that respect is geared not by the limitations that this court has regarded as essential to uphold statutes that govern potential forms of expression.
But whatever the expressions are, the conduct is, it has to be specifically intended to cause fear, intimidation, abuse, and it has to have actually caused fear, intimidation, abuse, or damage to property. I mean, doesn't that narrow it quite dramatically?
It fails to narrow it in this respect, that fear can be caused and be intended with the most simplest forms of expression, including expression that might even involve other civil rights, such as threatening, for example, your neighbor who keeps mowing your lawn that you're going to sue him. That's going to cause fear and fits squarely within the definition of the statute. And in fact, looking at the prior cases, A. Juvenile and Welch, collectively, which I think are both the most relevant Massachusetts jurisprudence, there have been in the case of Welch, in the criminal harassment statute, substantial limitations, including a reasonably objective standard, as well as a requirement that the harassment cause serious alarm or substantial emotional distress. Those are two factors. And also Justice Cowan in that decision was precise in indicating that another important aspect of these statutes is a clause that would limit the statute to not apply to protected speech. That also is absent from this. So that's
yeah, but those were read in. I mean, the limitation.
No, the statute used the objective standard itself.
Yeah, but this whole business about the statute was not to apply to constitutionally protected activity. That was read in by the court.
That is correct. It was read in.
Right.
But there were the statute had specific language that demonstrated an intent by the legislature to limit that type of criminal harassment to fighting words, essentially, to the type of speech that is not protected. This statute has none of those limitations. And in fact, whether your fear is reasonable or whether you're sort of the soft-shelled person who feels fear, even if it's unreasonable, then you're going to fall within this. You will have, because it's geared by intent. Even innocuous speech could have, if craftily formulated, can have the most malicious and hostile underpinnings below it. Sometimes it's even worse than the overtly expressed, violent, and profane type of speech.
Are you making both on its face and as applied challenge?
That is correct. That it's unconstitutional per se, on its face and in its scope, what it covers for not only speech but conduct. I mean, this statute's that broad. And
Well, it gets to speech as conduct, right?
That's
I mean,
correct.
or, yes, speech as conduct. I mean, it has to,
Right.
it doesn't get to speech per se, it's conduct, but you're saying speech, conduct can be speech, is where,
I am saying that also that the statute is in lacking a reasonably objective standard and being, in determining what falls within it, all the factors are driven by intent, even conduct might, none of the facts are in this case, everything was speech in this case. But, filing a lawsuit would fall under this statute. That would be protected. It's not a good example because there's other jurisprudence that protects that, but including anti-SLAPP legislation. But anything you do that's designed to cause fear and does in fact cause fear falls within 258E.
Well, would you feel better if we narrowed fear to fear of physical harm, the same way they define abuse to include physical harm?
The difficulty with following the line of cases that have construed this language to be limited to those forms of expression that are not protected, as in this case, all of the, including the reasonableness standard and the substantial impact requirements, to read those into this, it creates too much of a risk that expression is dimmed. And that's a juvenile, which is looking at these statutes and strictly construing when they can potentially cover expression is a more careful endeavor, because the person who's going to express themselves may never do it if they can't understand that this statute doesn't cover them. And this statute has no limitation.
But by that argument, we could never save a statute by narrowing its scope unless the legislature did it itself. Is that what you're saying? Is that a court can never save a statute from being deemed unconstitutional by narrowing it through interpretation?
What I'm trying to say is that the statutes that have been saved through interpretation have had some hinge, something to grab onto to say that's what the legislature intended. Here it's so broad that none of those are present.
Well, it's not. I mean, the abuse definition incorporates physical harm, intimidation. I mean, why is physical harm not understood to be that which the legislative purpose was designed to address? The fear that someone is going to be hurt.
It's disjunctive. So if it causes fear, abuse, or damage to property, at least so much of the statute that is designed to prohibit speech and conduct that actually causes fear is separate from so much of it that pertains to the abuse. And the statute does go on, does have specific items that can result to a harassment prevention order, including sexual assault and statutory violations. And I guess to be clear, those aren't before the court. My argument that the overbreadth and per se and as applied is limited to the facts I have, which is an actual form of expression. So that first portion of the statute, namely harassment, subsection 1, 3 or more acts of willful and malicious conduct aimed at a specific person committed with the intent to cause fear, intimidation, abuse, or damage to property, and that it does in fact do that. The expression, conduct, whatever it may be, that covers is so vast. It just covers a large, it just blankets out too far to cover all forms of expression, and including in this case something that's been addressed on multiple occasions, which is extending the middle finger, the flipping the bird, for the lack of a better expression, and that's what the statute was applied to, not surprisingly by the judge because of its breadth.
what's the status of I understand that there is a criminal indictment pending?
The
For the very same acts, nothing more?
The criminal indictment has been resolved. Attorney Lesser represented the defendant, so I don't want to get it wrong, but I think most of the stuff was dismissed.
So there's no more criminal indictment pending?
No. and the order has expired. And that was one of the issues that was reported. And regarding mootness, I think a lot of the tracks have been laid in prior cases with regard to restraining orders. They're not only capable of repetition yet evading review, they're almost certain to repeat and evade review, just given the timing. This one came up on appeal on a very fast track and still was expired by the time we were here.
Now, if we were to define fear to be fear of physical harm, what conduct would remain that you would say would be properly protected, given the requirement of intent?
Well, with the lack of an, if the court were to construe this to apply only to the fear of physical harm, it would be not only that would be read into the statute. Another aspect would have to be read into the statute. I believe what the question is whether you do that and it's a reasonable fear, because that isn't in the statute either. So those are two aspects that are the biggest problems for a constitutional overbreath challenge.
But if it's intended to cause fear of physical harm, and in fact causes fear of physical harm, why isn't that enough? Why does it have to be, and to an objective person it might cause fear of physical harm?
That's what saves it from the fighting words.
Because if your fear of physical harm has nothing to do with the expression.
But I intend to put you in fear of physical harm. That's what I intend when I do something, part of which includes words, and I do. I mean, threats, aren't threats enough?
The problem with that is that
implicit threats?
That when you say that if you intend to do something for purposes of the First Amendment, it never makes a difference, because that's what saved these statutes in the past, because it's what actually is being said that's prohibited. The intent is irrelevant. The worst of intents are not can't be regulated by these statutes, and
You do more than it's more than intent. You do something willfully and maliciously, which in fact places someone in fear of physical harm.
What if I intend to place someone into physical harm by working out and I get large and I say things that are not a threat at all and it places them in fear of physical harm, and there's no reasonable standard.
Your conduct has to place them in fear of physical harm.
Right, but if it's not a reasonable fear and this statute doesn't have that limitation, they've been induced to be feared by something that is perfectly within my civil right.
Yeah, but here's my problem with that. Let's assume you have a man who's abused a woman in a particular location, okay, at a Red Sox game, okay? And so every time he says to her, let's go to the Red Sox game, she understands that to be a threat of a recurrence of the sexual assault. Nobody else would understand that to have that mean. So if you import this reasonable person standard, don't you then encourage those threats simply to be more person-specific, to sort of to evoke memories that may not be shared by others, but that person may understand is a serious threat?
The reasonable person standard in that instance would the prior events would play into whether that fear is reasonable.
So is a reasonable person knowing all that the purported victim would know?
That's correct. I think when you look at this statute, and I'll wrap it up, when you look at this statute, you're left wondering if you're going to say anything rude or impolite or vulgar to someone, you are going to be wondering whether you are placing them in fear because what you're saying is motivated by hostility or revenge or cruelty. So much of what happens...
And it's intended to place them in fear.
That's right.
Of physical harm. Let's assume we take that. It's intended to. It does. And it's done maliciously. And you say that's as long as there's a speech element to it, it's constitutionally protected speech.
In that instance, what you're doing is modifying all the other propositions in there with the fear of physical harm.
I only modified one, I thought. Fear of physical harm. All the others, willfully, maliciously, intentionally, directed at a specific person.
It's intimidation too, and fear and intimidation.
Okay, and that's what it's intended to intimidate you. What does intimidate mean?
Well, they don't define that. They define malicious, which is characterized by cruelty, hostility, revenge. Again, 3 terms that are so vague and broad, they can encompass a large amount of what we say and what we do. And in a culture where we gear, in the marketplace of ideas, we gear what's pleasant conversation by what's unpleasant. So the statute, that's essentially the challenge, that the statute in having those aspects to be prohibited, cruelty, hostility, and revenge, and causing fear and intimidation without a reasonableness standard and without a requirement that it be substantial or serious, it fails for those reasons.
Thank you, counsel. Your time is up.
Chief Justice and Associate Justices, may it please the Court, my name is Eric Lucentini, and I represent the appellee in this matter, Mr. Borowski. This statute doesn't leave anybody wondering anything, in fact, and I wonder just...
It's not vagueness. The question is whether it impinges on First Amendment speech rights.
That's correct,
It's
Your
not
Honor.
vagueness.
That's correct, Your Honor. Initially, and maybe to state the obvious, this statute is presumed to be constitutional, and every possible indulgence needs to be given to that presumption. If this Court can construe this statute constitutionally, it must do so. And respectfully, it is Mr. O'Brien's task to, as the party challenging this statute, to demonstrate its unconstitutionality, and respectfully, I would submit that he has not done so. With respect to the overbreadth argument, looking at the plain language of this statute, the language gets at its central purpose. The purpose is to curtail harassing conduct in the furtherance of the Commonwealth's plain and substantial interest in ensuring the personal safety of all residents of this Commonwealth. And personal safety, as addressed right on the face of that statute.
Your client was fear of personal safety because somebody flipped him the bird, to use the expression?
Excuse me, Your Honor?
Your client was put in fear of personal safety because somebody gave him the finger?
There was far more than that, Your Honor. Factually, on an as-applied basis, with respect to the as-applied portion of this of the argument, there was far more. My client was followed outside of a bar, subjected to personally abusive epithets, followed to his home on 2 separate occasions, subjected to 2 separate drive-bys in which he was given the finger pointing out of a car. The car was paused in a menacing fashion, on and on. The district court judge, as for the as-applied aspect of this argument, the district court judge carefully reviewed and credited Mr. Borowski's testimony and his specific fear. He actually indicated that he felt threatened by the repeated conduct, which met the elements of the statute. So on the as-applied basis, yes, absolutely, without a doubt, no question about it. But getting back to the overbreadth argument, not to belabor the point, but this is civil legislation that allows a court to help an individual who has been specifically targeted by a pattern, 3 or more, of willful and malicious conduct, harassing conduct that is intended to and actually does put its target in fear or intimidation.
But in fear is a very broad word. Fear of what? Fear of collateral consequences, civil consequences, legal consequences. We can be in fear of lots of things.
Fear of physical harm, Your Honor.
So
and
you would read the statute for
I would
physical
absolutely, without a doubt, given and to get at terms like fear and intimidation, because one could nitpick. One might nitpick, and one might say, "Oh, the term fear isn't defined. Oh, the term intimidation isn't defined." But with respect to that, I would look, for example, let's take intimidation. There's a case from 2003 that came out of the Supreme Court. It's called Virginia v. Black. That statute simply said that if you burn a cross on somebody's property with the intent to intimidate, there wasn't even an effect component, with the intent to intimidate, that's going to be criminal, not subject to a restraining order. It's going to be criminal. In fact, it's going to be a felony, that Virginia statute. The court had absolutely no problem, there's no even discussion that the term intimidate under those circumstances would be a term that would be required to be defined under a statute of that sort. In this particular case, we have a willful, and again, all of the language needs to be taken together. It is willful and intimidating harassing conduct. Harassing conduct has its own interpretation by the courts, tied to 43A on top of everything else. But a willful and intimidation course of harassing conduct that is intended to and actually does subject its target to fear or intimidation. These statutes obviously need to be taken with the real-life backdrop of what's going on in the Commonwealth. Safety. Anybody who has spent time in a family court, for example, knows the backdrop of violence that is present in a myriad of personal disputes. And this statute so clearly addresses it. And again, I keep bringing this back to the overbreadth doctrine and appellant's invocation of that doctrine, which does not even apply here. And the reason is this. To begin with, nothing in the statute seeks to suppress in any way, let alone criminalize any kind of protected expression. There's no question about it. On its face, the statute doesn't use terms like speaking, speech. It speaks to conduct on its face.
Would you agree, though, that I appreciate what you say about your facts, but presumably somebody who, let's say all that you had was 3 instances of your client being somebody giving him the finger. That's all. Nothing more. It would fit within the statute, wouldn't it?
No, it would not, Your Honor.
Why?
Because it would not be there would need to be a finding that it was intended to and actually did subject its target to fear or intimidation.
Well, but somebody could be feared.
Absolutely. And, Your Honor, here we're drifting again into the as-applied portion of the argument. What I would say there is that much of the case law, and in fact, this gets to the nuance of First Amendment.
Okay, you're right. So let's put as applied to a side. On its face, though, wouldn't the conduct I've just described, the person means it as speech. I mean, it fits right within the statute, doesn't it?
No, Your Honor, it does not. Simply giving the finger without more, as actually a lot of the cases that the appellant has cited, and a lot of cases regarding other potentially expressive, potentially offensive, or potentially abusive, because the same form of expression can be offensive in one context and abusive in the other. The case law tends overall to hold to this notion, giving the finger, burning a cross, using an offensive word without more. You see this language over and over in the case law. Without more, that's not going to amount to, for example, fighting words under Chaplinsky or a true threat. Without more. Right. The question is, does this statute get at something more? Yes, this statute gets at something more than that without more.
And
Your Honor, yes, by way of comparison, maybe it helps to compare some of the statutes that actually have been stricken on overbreadth grounds. When we talk about the kind of statutes that the Supreme Court has looked at and said, whoa, this statute, it can't stand too much speech, comes within the ambit of the statute. What we tend to be looking at is these open-ended criminal statutes, typically disorderly person statutes, or interrupting a police officer statutes, or speaking, using coarse language in the presence of a police officer, which was I believe it was Lewis versus New Orleans, for example. In all of these cases, which incidentally, they were criminal statutes, not civil statutes, so already there's a fundamental difference there. But in all of these cases, what did the statute do? It expressly, on its face, targeted speech to begin with. So already, that's something that's not going on here. But second, what kind of speech? Interrupting an officer? There's the Houston versus Hill case, for example, which was another Supreme Court case, which made it a crime to interrupt an officer. The Texas courts had used that statute to prosecute people for simply expressing themselves at a police scene, for walking across a police scene. Any kind of publicly acceptable expressive conduct could be captured within that statute. And in fact, if you look at a statute from that perspective and the use that police put to those kinds of statutes that were, again, because they targeted speech, they were suspect in a sense, and the overbreadth didn't even have to be so broad. Because in a situation where we're regulating pure conduct here, the overbreadth doesn't even have to be real. It has to be substantial as with respect to the legitimate sweep of the statute. Substantial. Otherwise, the statute is fine, and the doctrine can't even come into play in the first place. But with respect to those particular statutes, those disorderly person conduct statutes, even the statute actually that this court ruled could not be applied to speech in Commonwealth v. Juvenile, the 1975 case, which also incidentally involved a disorderly persons statute that this court had, in an earlier decision, Allegata engrafted on a provision of the model penal code, which on its face also criminalized speech. In all of those cases, here's the common element. A cop can look at somebody on the street he doesn't like and seize upon just about anything that that person says, say it's interrupting him, arrest him, and let courts on an as-applied, on the as-applied part of the argument, on an as-applied basis, determine who's going to be convicted or who may have been expressing free speech. And the Supreme Court actually, in the Houston v. Hill case, they called that a dragnet statute. Dragnet statute. That's what overbreadth is getting at. Dragnet statutes. Substantial overbreadth. Nothing, but nothing about this case is even remotely the kind of language that would cause a court to invoke the overbreadth doctrine. This language is carefully tailored. It's getting at a specific purpose. I don't know how much more a court could tailor it. Are there possible scenarios where the statute could be applied unconstitutionally? Of course. I mean, a law professor could come up with some. I could sit here with my law partner and we could ponder it for a while. We tried, actually, and we had difficulty, frankly. But we could try, probably come up with something. The fact that a statute might be, under some certain circumstances, applied unconstitutionally, by no means renders the statute impermissibly overbroad. That's just not how the doctrine works. And in fact, as I say, in a case of a statute like this that's been so carefully tailored, the doctrine simply doesn't come into play, so that if somebody has a problem with the statute, they certainly are free to challenge the application of the statute to a particular set of facts.
Let me ask you a question in a slightly different way, which is to try to get at the purpose of this statute. What does it do that 209A doesn't do, other than who it affects? I mean, who can seek its protection under it?
The way I read the statute, it is sort of a hybrid statute because it captures certain provisions and concepts from 43A, the criminal harassment statute, and certain concepts from 209A, which is the element of getting this protective order, for example. So it actually provides a really excellent tool that's available to everybody. In addition to that, incidentally, it also borrowed language from a Maine civil harassment statute. Specifically, that intent and effect and the use of fear and intimidate as opposed to seriously alarm, for example. Fear and intimidate, incidentally, as I say, in the in Black v. Virginia, for example, when Justice O'Connor looked at that language and didn't for one second think that intimidate needed to be defined. Alarm certainly does need to be defined. And this very court in the Welch case talked about how a term like alarm can be on its face. You know, anything can be alarming. So clearly, in the context of 43A, when the legislature used the words substantial alarm, there was a reason to modify that term. But when you're talking about fear and intimidation, fear, I would respectfully submit, is different from alarm. And so there are these, so it's different from 209A in that sense that it borrows harassment concepts from 43A. It borrows certain concepts from 209A, including the definition of abuse from 209A as well, which is one of the types of conduct that's captured under the statute. And it also borrows from this Maine statute. What I want to point out about the Maine statute, incidentally, is the operative language of this Maine statute. At the time that the legislature unanimously enacted this provision of 258E, that Maine statute had been on the books, and I encourage the court to have a look at it. It's Maine Annotated Statutes, Section 4.6.
But it says 3 or more acts of intimidation, confrontation, physical force, or the threat of physical force.
Correct. So it's somewhat different.
Yeah, that's an in-your-face, direct, fighting words type of scenario, which is spinning out there, right?
Well, Your Honor, yes, but again, it's a disjunctive, so it can be an act of intimidation, which is, again, the word that's used in our statute. So there is a mix of the language. There's no question about it. It's not identical.
As opposed to 3 or more acts that cause fear.
3 or more acts that cause fear, correct,
Which is
Your
a
Honor.
very
And
looser,
that's another, excuse me, Your Honor?
that's a much looser general concept than 3 or 4 acts of intimidation, confrontation, or physical force or threats.
Well, I suppose an act that causes fear or an act that causes intimidation, again, I would submit that these terms are susceptible of having a constitutional meaning against the backdrop of the statute and against the purpose.
Well, I mean, to the extent, if we were to view fear as meaning fear of physical harm, that's much more in line with what it appears Maine is all about, as opposed to fear from some other kind of harm.
Yes, Your Honor, and again, and that's perfectly, that is correct, Your Honor, and actually that does get at this notion of the physical harm component here, which actually leads me to one last point I want to make, which is on the topic of a limiting construction. Should there be any doubt whatsoever as to the facial constitutionality of the statute, this Court will have no problem whatsoever in grafting a limiting construction if that's what this Court wants to do. If this Court wants to import some kind of an objective standard, physical harm, there's no problem with any of that. In fact, simply look at the Chaplinsky case. I mean, the statutes that have been construed and narrowed have been so open-ended. If I could finish, the Chaplinsky case, for example, an open-ended speech-regulating statute that the New Hampshire Supreme Court, in that case, it was open-ended, right? Insult somebody on the street. New Hampshire Supreme Court construed that case in a limited manner simply to apply to fighting words. And the Supreme Court said that's fine. That's fine as a limiting construction. If that statute in Chaplinsky can be limited like that, then I would respectfully submit that this statute, as carefully tailored as it is, can certainly be limited without any difficulty.
Do we know here that the judge, when he made his or her finding, relied upon fear of physical harm as the basis?
Your Honor, I would look at I believe that the final judge's order did not incorporate any particular findings of fact, but they were reflected, in a sense, in the judge's commentary toward the end of the transcript. And the judge seemed to be indicating that there would be a fear of physical harm. The judge said, when I go home, if somebody follows me, that's going to scare me. The judge seemed to be incorporating some of the testimony that Mr. Borowski had given. Yes, Your Honor.
Thank you, counsel.
Thank you, Your Honor.